Hello, I'm Professor Lolita Darden, and I'm the Director of the Intellectual Property and Technology Law Clinic. We are a pro bono community service clinic committed to reducing the innovator diversity gap and increasing the number of diverse innovators and creators that use U.S. IP laws to protect their innovations, creations, and brand symbols. To achieve that goal, we primarily serve clients from under resourced communities and women. Our clients are typically individuals, entrepreneurs, and small business owners, which may include artists, musicians, singers, inventors, movie producers, consumer and electronics product companies, and medical device innovators, just to name a few. Students have an opportunity to represent clients on a variety of IP and technology matters related to patent, trademark, and copyright protection. The clinic is divided into two tracks: patent and soft IP. Students electing the patent track should have a degree in engineering or science. Students electing this track will learn to conduct a patent search, evaluate the search for issues of novelty and obviousness, draft and file a patent application, and respond to communications from the patent office as part of their client representation. Students electing the soft IP track will learn to conduct a trademark search, evaluate the search to determine whether a trademark is eligible for use and registration, respond to office action communications from the trademark office, both substantive and non substantive actions. On the copyright side of things, students will learn to prepare copyright registration applications, understand the procedures for representing clients before the Copyright Claims Board, and complete various transactional matters such as preparing license agreements as part of their client representation. Although the clinic is divided into two tracks, students have an opportunity to counsel clients on IP matters that fall outside their elected track. For instance, students electing the soft IP track will learn basic requirements for patent prosecution, and patent track students will learn practice skills related to trademark and copyright protection. Students seeking to join the clinic should have completed on the patent track, completed the patent law courses, the basic patent law courses, and the advanced patent law class. Students electing the soft IP track should have completed the trademark law course and or completed the copyright law class. I'm looking for students who are passionate about intellectual property law practice and have a desire to work with the clients that we serve.
Hi everyone, I'm Emanuela Safro. I'm a third-year law student and student attorney in GW Law's Intellectual Property and Technology Law Clinic. I'm excited to share my experience with you today and give prospective student attorneys a sense of the type of work that you may be doing in this clinic. First, I'll share an overview of the clinic. Then I'll discuss my experience, the time commitment, and the skills that I have gained so far. So, the IP and Technology Law Clinic is one of the newer clinics at GW Law. We represent individual inventors, entrepreneurs, and artists who need IP legal assistance who could not otherwise afford counsel. There are two tracks in our clinic. The first track is for trademark and copyright law students, and the second track is for patent law students. Despite your selected track, you will have an opportunity to navigate the patent and trademark prosecution systems and the copyright registration process. You will have this opportunity through the comprehensive 2-hour seminar and by working with your paired co-counsel on a different track. I have had a phenomenal learning experience so far as a student attorney in this clinic. I'm on the trademark and copyright track, and as such, I provide counsel under our director's supervision to small business owners and up-and-coming artists who want to register their trademarks with the USPTO. As it pertains to the time commitment, our clinic is 6 credits, and so I spend about 21 hours per week on client matters. This includes researching the TMEP, preparing client correspondence, reviewing USPTO guidelines, preparing applications, and submitting biweekly journal reflections. The 21 hours a week time commitment also includes attending a 2-hour seminar taught by our amazing clinic director, Professor Darden, and a weekly 1.5-hour supervision meeting. Finally, I have developed tremendous skills in this clinic so far. I have learned how to effectively conduct a trademark clearance search, how to respond to a USPTO office action, how to prepare a trademark application, and how to counsel a client who is deciding which Creative Commons license is most effective for their artwork. I'll leave you with this. Gaining practical experience in intellectual property law as a law student will give you a unique advantage once you graduate. I really hope you decide to apply for the IP and Technology Law Clinic. Thank you for listening.
Hello, everyone. My name is Bree Schulich, and I'm a 4LE at the George Washington University Law School and a student attorney in the Intellectual Property and Technology Clinic. And today I am excited to share with you some of my experiences thus far with being a student attorney in the IP and Tech Clinic. So to kick it off, as it pertains to a time commitment, the clinic is 6 credits, so there is a fairly substantial time commitment associated with the work that we do. I would say in total, I spend about 15 to 20 hours per week on clinical work. That does include a 2-hour meeting where we collectively come together, and it's a bit more of like a lecture style, and then a 1-hour supervision between myself, the director, as well as my co-counsel. And the rest of the work is typically spent doing client meetings, and then of course, drafting patent applications and or official communication with the United States Patent and Trademark Office. In terms of skills learned thus far, I would say project and also docket management have really been instrumental, and my skills have sharpened in both of those areas, just given the dynamic of having professional employment outside of the clinic, a course load to manage, as well as a clinical caseload to manage. So that has really been fun and a great learning experience. I think second to that, the actual patent drafting, claim writing, technical skills have been improved just by way of repetition, receiving feedback, as well as the ability to communicate clearly, effectively, and concisely in a way in which clients are able to understand their intellectual property protection rights and which direction might be most beneficial for them given their ultimate goals. And so I think lastly, I did also want to mention that the teamwork aspect has really been incredibly important. We have team managers for different clients and different cases, and we're able to work together collectively and holistically to be able to serve the client to the best of our abilities. So I really, really enjoyed that. And I think finally, I'll say the clinic is new, and we just started in January. It's the end of February now, and we did have the opportunity to file a provisional patent application already last week, which was incredibly rewarding and fulfilling. And the inventor expressed just the sincerest amount of gratitude and shared with us that, you know, if it weren't for us, she would not have had legal representation and thereby potentially not been able to file a provisional patent application and now have patent pending as we work to finalize her application and submit a non-provisional as well. So all in all, I think if you're at all interested in the IP and Tech Clinic or any other clinical program, that I would recommend without reservation and encourage you to chat with student attorneys and or directors of the program to learn more and consider applying. So thank you all so much for your attention.